Welcome to this Australian Law Journal webcast. I'm Justice François Kunc, the General Editor of the Journal, and it's my pleasure to welcome one of my Associate Editors, Dr. Ruth Higgins, and our very special guest, Professor Martha Nussbaum. Welcome, Professor.
Professor, some of the people watching this may not be familiar with your background. Can you tell us a little about your history and formative influences and how a philosopher ends up in a law school with connections to classics, divinity and political science?
Well, of course, I don't know whether you want the long, I guess a pretty short version. So I had a very happy early life in a wonderful school that was for women, where the best thing in it was the drama. I mean, I got a very good intellectual formation, but I loved acting because it was it was sort of upper crust Protestant society, which was very emotionally restrictive, and it was in the theater that I got to have more understanding of what the emotions are and how they contribute to human life. So that stuck with me, and I thought I wanted to be a professional actress. Did that for a little while, realized I didn't want to be a professional actress. I wanted to think and write. But that spirit of the arts has always been with me. And so then I went to graduate school actually in classics because I wanted to think and write about the Greek tragedies, which I've done. But I shifted quickly into an interdisciplinary program with philosophy. And my first writings were really about the relationship between Greek tragedy and Greek philosophy. But since I thought this is important stuff for modern ethics too, very quickly I moved into just philosophy and writing about the importance of these things, including the literary works for philosophy. Now, where does law come in? Well, you know, I'm a pretty political person. I want to try to figure out how an intellectual can influence this diseased political culture in America that I'm talking about. And I thought there were actually two ways, and one is through international development work, which I've done quite a lot of in partnership with economists. But the other way is through law. And it's kind of an easier route because you're teaching people who will be judges, who will at least clerk for judges if they're not judges themselves. And, you know, maybe a little of what you teach could make a difference. And since America is very receptive to interlopers like me, I got an offer to come to University of Chicago, which I adore. And I think it's one of the best places, if not perhaps the only place, where I can do this fully interdisciplinary thing. And so I don't just teach half and half, but every course I teach is kind of some students from philosophy, some students from law, and they all kind of mix together talking about emotions. Reason and law is one course that I teach, for example. And it's great to have that mixture of students. And I think it's probably good for the law school to have these interlopers there.
Let me pick up on that emotion, reasons and law. One of our most famous Australian judges talked about strict and complete legalism, something completely drained of emotion. But emotion plays a very important part of your work. And an Australian academic has written that you insist that our emotional involvement with the world is not the negative of reason or the opposite of justice, but is the very thing that gives judgment a basis on which to operate. Do you agree with that?
Well, I would go even further because it's actually my view that emotions embody judgment, that when you have an emotion like grief, it involves the judgment that some very important person is gone. If you have anger, it involves judgments about what wrong has been done. It would be good to set that to rights and so on. So the emotions are not just like blasts of energy that course through your system, but they're actually forms of intelligent thinking. Even when animals have emotions, it's got thinking in it of their own characteristic sort, like danger ahead. And so you know, when I teach that course, I really want people to see that the emotions they can be based on bad thought, and they can embody defective forms of reasoning, and they often do, but they're no more likely to be astray than other forms of belief. Of course, beliefs can be bad too.
Changing topic a little, Professor, is there an old quarrel between philosophy and poetry, and if so, do you take a side?
Well, you know, Plato, of course, says that. Now, Plato was a philosopher who believed that you should never trust the emotions, not because they were lacking in judgment, but because the judgments on which they rested were, in his view, all false, because they gave too much importance to things like friendship, citizenship, all the external things you don't control. So he was very like the later Stoics in thinking you should be detached from all those things. And of course, literature tells you no. Life can go hideously wrong on a large scale. And so one of the passages that Plato hates and wants to ban from the ideal city is where Achilles is grieving because the man that he loves most has died, and he's rolling in the dirt and rubbing ashes all over his body. But of course, that's how you should behave when somebody you deeply love has died. So I think the quarrel was about substance. It was about what should you care about. Plato thinks you should care only about your reasoning. And Socrates, as he portrays him, is a very cold figure. He doesn't love anyone. And so since I think you should love people, then I think the literary works are often allies, because I don't think there's any literary work that tells you you should never have love, or if there is, it would be only in a very weird way that it would do that.
Why does teaching people about that make them better lawyers?
Well, you know, there's so many places where emotions come into the law, and in this class that I teach, I focus on criminal law and constitutional law because those are two areas of law that I kind of know something about. But there are all kinds of ways in which key legal concepts are defined in terms of emotions. Reasonable fear in the law of self-defense, reasonable provocation in the law of homicide, the disgust of the average man in the law of obscenity. And then in constitutional law, well, of course, that is already constitutional law, and there are lots of other cases in constitutional law. In fact, Andras AO, the European Constitutional Court judge, wrote a whole book about how he saw fear as lying at the foundation of all constitutions, because people put down in the Constitution the record of what they think is most to be feared, and they want to stop that and give the opposite thing extra protection. So I think it's all over the place, and you really do need to understand it if you want to have accurate judgments. One of the exam questions I sometimes give is, suppose now you go and you're clerking for a judge, and your judge says, well, I see you took this course on emotions, reason, and law. Write me a memo about the difference that would make to this case, and then I give them a hypothetical. And, I think it does make a difference. Because if, for example, you think that fear is just a jolt of energy, then you will not really understand what the common law means by the concept of reasonable fear. You'll think, well, it's either strong or weak, but surely fear can't be reasonable. But of course, the common law doesn't think that way. They think that fear could be provoked by a certain kind of information about what's impending, and that information can be true or false. And the thing that is impending could be more or less important. So if you shrink and you kill somebody because they forget your name, that's one of Aristotle's examples of unreasonable fear. So if you forget my name and I suddenly stab you, I'm not going to be able to plead self-defense. So that's what we mean by reasonable fear.